I'm attorney Robert Flesses, and today I'm discussing the importance of properly dealing with a marital home before you finalize your divorce. If you listen to this entire video, I'm going to tell you why you should be concerned if you're getting a divorce and you own a home. If you're planning on getting divorced, you may want to take advantage of both my 27 years of being an attorney and 32 years of real estate brokerage experience to help you. By doing that, you're putting the massive power and experience that I have on your side in a divorce. When a happily married couple purchases a home during the marriage, both the husband and the wife's names appear on the property's deed. More importantly, both names also appear on the mortgage, which binds both parties to repayment of the mortgage balance. Here's a typical fact situation. A couple gets married, they buy a home, have children, and raise the children in the marital home. Over time, marital problems start. After valiant attempts to reconcile their differences, a divorce is filed. One spouse moves out and the other spouse continues to occupy the home. A home is one of the most significant assets in a divorce case, but many people fail to properly address the disposition of their home in a divorce. Instead, many rely on the verbal promises made by the other spouse who wants to keep and reside in the home. The spouse that moves out is usually driven by their desire to just get out of the marriage, which clouds their better judgment. And I'm not implying that you should stick it out in the home when you're having problems. That has no bearing on whether or not you live in the house based on what I'm about to tell you. The question becomes, how do the parties deal with the disposition of their home before signing the marital settlement agreement and closing out the divorce case? When faced with this situation, the party that moves out of the home is usually operating off of a verbal promise that the residing spouse makes. And the spouse that wants the home states that they'll refinance the mortgage into their own name, releasing the other spouse from the mortgage obligation. But does that spouse have the credit worthiness to get a new mortgage? Or the spouse remaining in the home claims that they will sell the property and disperse any equity in the home equally with the other party. We've all heard the phrase dragging their feet, right? More often than not, promises never materialize, and the spouse that gets burned regrets the fact that they trusted the person that they were divorcing. Signing a quitclaim deed doesn't solve the mortgage issue either, because you're still legally obligated under the terms of the mortgage, and you can suffer substantial damage to your credit if things go wrong. All you did by signing over the deed was to hand over your legal rights to the home to your soon-to-be ex-spouse. Here's how you solve the problem. First, never sign a quitclaim deed until the following is performed to your complete satisfaction. Signing the quitclaim deed is the first warning that you should heed that you're about to get burned really bad. And if you don't have a lawyer who's experienced in both real estate and divorce, the chances that you'll get burned multiply exponentially. Before the marital settlement agreement is signed and submitted to your judge for approval, all of the home disposition contingencies must be addressed in writing so that the contingencies are enforceable after the divorce. Verbal promises mean nothing. Maintenance and child support have nothing to do with the disposition of your home. Neither does the disposition of retirement accounts and other marital assets. Threats to take children away from you are also false. A home is a separate item that needs to be addressed independently before the divorce is finalized. There are two general options. One, put the home on the market. You insert an agreement into the marital settlement agreement stating that the home is to be sold and the equity, if there is any, be equally divided immediately upon the closing. This option requires very specific language that lays down the deadlines for each and every task that must be performed in order to accomplish the sale and the closing. Also, enforcement contingencies must be inserted into the agreement in the event that the residing spouse fails to comply. I'm very good at doing this for you. By the way, with all due respect to realtors, they should never be relied upon to craft language that is to be inserted into a marital settlement agreement for a home sale. And if they do, they're engaging in the practice of law, and that is a big-time violation. Some divorcees see this as the cheap option to avoid obtaining the services of a qualified attorney. Some divorcees try to insert their own language that usually fails to cover all of the contingency rules. Some parties just don't care. You should care. The second option is usually not achievable and is the most dangerous. The residing spouse tells the non-residing spouse to sign a quitclaim deed relinquishing their ownership rights, and in turn, the residing spouse promises to pay the monthly mortgage payments and refinance the mortgage into the residing spouse's name. Does the phrase dragging their feet ring a bell? What if the residing spouse does not refinance despite continual promises to do so? What if the residing spouse fails to make the monthly mortgage payments? As time goes by, the non-residing spouse, despite the execution of a quitclaim deed, still remains legally responsible for the payment of the mortgage. If the residing spouse stops paying the mortgage lender files a foreclosure action, and guess what? The non-residing spouse that's been trying to establish their own credit and get a new life gets dragged into a foreclosure lawsuit as a party to the mortgage. Now the non-residing party's creditworthiness is damaged, and good luck trying to get a mortgage to buy a home in the future. So the moral of this video is that the non-residing spouse needs to protect their interest in the home before signing a marital settlement agreement and getting the divorce. You need to deal with the problem before you get divorced. That's why if you hire me to protect your financial interests as your divorce attorney, you're going to get somebody that's going to really help you. When you do hire me, you get the advantage of my 32 years of real estate broker experience and 27 years of being an attorney to get your divorce done the correct way. I'm attorney Robert Flesses, and thanks for watching.